In every sentencing, there is a range, and where I land inside that range is my responsibility. In this case, I chose the lowest end of what the law allowed. I want to tell you everything I saw that made that the right call, because it was not obvious from the outside, and it should have been. Months later, I learned that every Thursday at 12:18 p.m., during a lunch break that was not really a lunch break, he was carrying insulated meal trays into St. Raymond's Senior Meal Center on Potters Avenue before rushing back to work. I heard that, and I thought back to the afternoon he first stood in front of me, facing a number large enough to break a man who was already bent. I want to tell you how we got there. When the file first crossed my desk, it looked plain in the way hard cases often do: municipal penalties, property damage, a business owner seeking repair costs and lost income, a man driving an overused delivery van with unpaid assessments attached to it, total exposure a little over $5,000. On paper, there was enough there to move quickly if I wanted to. I did not want to move quickly. The law gives me facts first. It is my job to find out whether the facts are standing on top of a fuller truth. I looked again at the employment line in the file. 3 jobs. That did not excuse what happened. It told me only this: if I listened carefully, I might find a door the file itself was not showing me. Subscribe before I go further. Cases like this one do not happen as often as they should, and they deserve to be documented and heard the same way the harder ones do. Subscribe so you are here when I get to the part that made me remember why I chose this work. His name was Luis Santiago. He was 36 years old when he walked into my courtroom on May 9, 2025. Before testimony began, I noticed one small thing. He had a blue work polo under a gray sweatshirt, and in his back pocket was the folded edge of a white bakery apron. He had dressed for more than one shift because his day was still going after court. When he got to counsel table, he did not sit right away. He took a lunch receipt from his wallet, flattened it against the wood, and tucked it back in as if even a scrap of paper had to be kept from getting lost. That told me something true before he ever spoke. Some people under pressure let the small things go. Some hold on to them because the small things are the last proof that they still have a hand on their own life. His hands were rough. There was a fresh split in the skin near his right thumb. He looked once toward the back doors, not like a man planning to run, but like a man keeping track of time even while standing still. The woman who owned the damaged storefront was Maria DeLuca. She ran a stationery and lunch counter on Westminster Street. She came in with repair estimates, photographs, and a ledger. She was upset. She had every right to be, but she was careful, not loud. Before we began, I watched her organize her folder into 3 stacks and label them with a black pen: glass, awning, sales. From the bench, I could see that. Most people in the room could not. That mattered to me because it told me what kind of case this might become. She was not there to make a performance out of being wronged. She was there to name what had happened to her business in exact terms. Later, that precision would matter more than any show of anger could have mattered. The incident itself took place on Friday, April 18, 2025, at 12:43 p.m., outside 212 Westminster Street in downtown Providence. Luis was driving a white 2008 Ford Econoline van for his midday delivery route. He had pulled into a yellow commercial zone in front of Maria's store to unload lunch orders for an office 2 doors down. A parking enforcement vehicle came around the corner. Luis ran back to move the van. He pulled out too fast. The passenger side mirror caught the steel arm of Maria's sidewalk awning. The arm snapped loose, the front window cracked, and part of the frame dropped low enough that she had to clear customers out through the side door. No one was cut. I want to say that plainly. But harm happened anyway. Maria lost the rest of that lunch rush, most of the next day, and money she had expected to earn in a narrow part of the week when lunch traffic pays the bills. The city cited Luis for negligent property damage, unsafe exit from a commercial loading area, and operation of a commercial vehicle without standing municipal assessments. That is how the number climbed. When he described it from the witness stand, he did not soften it. He said, "I heard the snap before I saw what I hit." Then he said, "I did that." I remember those lines because he said them before his lawyer could shape them into something smoother. He did not glance sideways for help. He said them to me. Maria later confirmed one other fact. After the awning dropped, Luis did not leave. He parked crooked, left the van door open, and came back to hold the frame up while two customers stepped around the broken glass. That did not erase what he had done. It told me what he did in the first seconds after doing it. Courts should notice that. Subscribe before I keep going. I made a choice in this case that I want to explain fully. Subscribe now, because the reason I made it is coming, and I want you to be here for the whole explanation. There was a legal tool available to me in this case that I was glad to have. Under our municipal rules, I could separate restitution to the person harmed from the penalty owed to the city, suspend part of the city fine, and keep the matter open for review. Put plainly, I did not have to choose between hitting him with the full amount in one afternoon or acting as if the damage did not matter. I could build a structure and require him to prove he could live inside it. That is what discretion meant here. It did not mean I could ignore the law. It meant the law gave me room to consider hardship, conduct after the incident, restitution efforts already made, and whether a lower immediate burden might actually produce more accountability instead of less. Strict application would have been easy. Add the numbers, enter judgment, move the calendar. This asked more of me. I watch entrances closely because people tell the truth with their bodies before they ever tell it with their mouths. Luis came through the side door at 1:57 p.m., walking too fast, then slowed himself down 3 steps before the table, as if he knew speed was part of why he was there. He took off his knit cap before anyone asked him to. He stood with his hands open, not crossed, not hidden, and kept shifting his weight from one foot to the other, like a man who had another place he had to be and hated that he could not divide himself. Maria entered through the main doors 2 minutes later. From where I sat, I could see her read over her own notes once more before sitting down. Most people review notes because they are nervous. She looked like someone checking herself to make sure she said only what was true. There is a kind of calm that belongs to prepared people. She had it. Turn 1 came before the first exhibit was marked. Another case was finishing ahead of his, and while we waited, Luis leaned toward the court officer and asked if he could make a quick call if there was a pause. He did not know I could hear him. He said, "If I miss 2:15, my girls stay in the school office till somebody signs them out." Not a speech, not a plea, just a fact that existed whether it helped him or not. I let him make the call. He stepped into the hall, came back in under a minute, and thanked the officer before sitting down. That was the first turn. Not because fatherhood cancels negligence, it does not. It was the first turn because the file had shown me debts and violations. That sentence showed me the life those debts were landing on. It forced me to reconsider what kind of man I was reading on the page. Some people ignore obligations because they do not care. Some are crushed by having too many at once. I had not decided which he was. Now I had a truer question. The city put in the repair photographs and the penalty schedule. Maria's lawyer set the direct damage at $2,180 for the awning arm, the window, and labor, plus $1,460 in lost sales. The prosecutor argued for the full fine range because commercial zones in a crowded lunch district depend on people following the rules. He was right about that. Public order matters. Business owners have a right to rely on it. Then Maria spoke for herself and the room shifted. She said, "Judge, I want my awning fixed. I want him to slow down before he hurts somebody. I do not need $5,000 to prove my window broke." I remember that exactly. It was one of the clearest statements of need I have ever heard in court. Not softness, clarity. When she said it, Luis lowered his head so quickly I thought he had dropped something. He had not. He was holding himself together. Her own lawyer closed his folder halfway and left it there. From the bench, I saw both reactions at once. That is one reason I remember them. The defense began where it should have begun, with responsibility. Luis's lawyer said my client made a rushed and dangerous choice, and a working person paid for it. Good. That saved us from wasting time on nonsense. Then he gave me paper. Bakery pay stubs from 4:30 a.m. shifts, delivery logs from the lunch route, warehouse timesheets from 6 evenings a week. A school form showing he was the sole emergency contact for two daughters, ages 8 and 11. A pharmacy receipt for an asthma inhaler refill dated the same day as the incident. Then came turn two. In a clear plastic sleeve, the lawyer handed up 5 money order receipts totaling $300, all made out to Maria DeLuca over the 3 weeks before court. Small amounts, $40, 60, 80, 60, 60. Attached was a handwritten note from Maria that said, "Received. Thank you for staying in touch." The evidence did not ask me to feel sorry for him. It asked me to notice a pattern. He was already paying her before I ordered him to. That opened a different decision for me. Up until then, I had been thinking about whether I could justify lowering the immediate city burden. Those receipts showed me I also had reason to trust a payment structure if I built one carefully, not certainty. Judges do not get certainty, but evidence strong enough to support a plan. At that moment, I watched Maria press 2 fingers to the corner of her eye and hold them there for a second. She did not wipe away tears. She steadied herself. Luis stared at the table grain and did not look back at her. The room grew quiet in a way that was not theatrical. It was the silence of people realizing the facts were pointing somewhere different than they expected. I asked Luis about his workday. I wanted to hear it in his own words, not in a lawyer's summary. He said he started at the bakery at 4:30 a.m., left at 9 a.m., switched shirts in the van, ran deliveries from 10:30 to 2:30, picked up his daughters by 3 hours, settled them with his sister, and worked warehouse cleanup from 6 p.m. to 11 p.m. I asked him when he ate. He said, "My lunch break isn't lunch, Judge. That's when I change shirts, drop off medicine, and pray traffic lets me get to the next place on time." He said it with no strain in his voice, just honesty. That line did not decide the case by itself. It brought the shape of his life into focus. Subscribe before I continue. I have been building to something in this story, and it is not where you might think it is going. Subscribe and let me get there. The defense was asking for something I was already inclined toward by then. Restitution first, a reduced city penalty, and a review date instead of immediate collection. What confirmed that instinct was not hardship alone. Courts see hardship all day. What confirmed it was the order inside his hardship. He was not drifting. He was trying, imperfectly, to keep many obligations from falling on top of each other. And then the defense did one thing I respected. Luis's lawyer said, "Your Honor, 3 jobs are not only his hardship, they are part of the danger. If the court gives him a path, the path has to slow him down." That was honest. It did not flatter the client. It named the problem. There was one thing the defense got wrong. For a moment, counsel spoke as if the unpaid municipal assessments were just background noise in a poor man's life. No, those mattered. Each ignored notice narrowed his choices later. Each delay made the next failure more likely. I said so in open court. If I was going to show mercy, it had to stand on truth, not on excuses. Then Luis gave the line that settled the matter for me. He was explaining why he had sent Maria money orders before the hearing instead of waiting to see what I would do. He said, "I know what it feels like to wait on somebody who said they would come and then didn't. I won't do that to her." That was the moment I knew what I was going to do. I wrote it down, not because I needed to remember it, because I wanted to. That sentence brought back a scene from my own life I had not thought about in years. I was a boy sitting at our kitchen table. My father had just come home with plaster dust on his sleeves. He set down his metal lunch pail, opened it, and there was half an orange still inside because he had not had time to eat it. My mother slid a bowl of soup toward him. Before he touched the soup, he took a wrinkled paper from his pocket and smoothed it flat on the table with both hands. I can still see the dust in the lines of his fingers. I can hear the chair scrape the floor. No one explained the scene. No one needed to. Work had followed him home, and dignity had followed work. That memory sat beside Luis's case in my mind. I did not mention it in court. It did not belong in the record, but it belonged with me while I decided. Subscribe. Because if this case surprised me, and it did more than once, I think what comes next will do the same for you. Subscribe and stay with it. By the time we reached sentencing, I had what I needed. I had the full weight of the damage. I had Maria's exact statement of need. I had proof that Luis had started paying before he was ordered to. I had evidence of a life under strain but still trying to meet its duties. And I had lawful room to build something more precise than a number. Before I spoke, I looked out at the room. Luis had both hands resting on the table edge, flat and still. Maria had closed her folder and placed one palm on top of it. In the second row behind Luis sat his sister with his two daughters. The older one was doing homework on a yellow legal pad. The younger one was swinging one sneaker very slowly under the chair and trying not to. I had made this decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. I said, "Mr. Santiago, you damaged a working person's storefront. You interrupted her business. You made a public street less safe because you chose speed over care. I want you to hear that clearly before I say another word." He nodded. Maria stayed still. Then I imposed sentence. I said, "I am ordering you to pay restitution to Maria De Luca in the amount of $1,080, after credit for the $300 you have already paid, for a remaining balance of $1,580. That money goes to the person you harmed first. Broken glass and bent steel cost real money, and a business owner cannot build a day's sales back out of apologies. I want the payments modest if they have to be modest, but I want them steady. I am also ordering a city fine of $500 with $350 suspended on condition of full compliance. I am choosing the lower end because a punishment that takes away your ability to work will not make Ms. De Luca whole and will not make this city safer. But the city remains part of this case. Public rules matter, and there has to be a cost for violating them. And there is one more thing. I am ordering 60 hours of service with the St. Raymond's Senior Meal Program over the next 6 months. You know what it means to move meals on a clock. I want that skill used where it helps people instead of putting them at risk. I am not interested in idle suffering. I am interested in useful obligation. Then I added the structured part. You will complete a defensive driving course within 90 days and file proof of current insurance, registration, and cleared municipal paperwork for that van before your next review. The evidence showed me a man carrying too much. Carrying too much is not a defense when you are behind the wheel. I want your habits slowed down and your vehicle brought into order. Then the relational part. Every 60 days when you return to this courtroom, you will bring one signed note from an adult outside your home and outside your jobs, a school counselor, a pastor, a program supervisor, somebody who sees you in the world and can tell me whether your conduct matches your promises. Work can hide a man. I do not want you hidden. Finally, I gave him the benchmark. If you make 6 monthly restitution payments on time, complete the driving course, finish at least 40 service hours by your 4th month review, and receive no new moving or parking violations during that period, I will waive the suspended $350 and close the case early. Meet that benchmark, and you will have earned the reduction. Then I said the sentence I wanted him to hear plainly. I believe you can do this. After that, I addressed the case the way I needed to. I said, Ms. De Luca lost money, time, and peace in the middle of a day she had every right to count on. Mr. Santiago, the charges in front of me do not contain all of who you are, but they do contain a real failure that cost another person something real. What you do next will matter more than anything you say right now. Be the man your daughters think is coming when he says he is on the way. Subscribe. What I said from that bench was the hardest good thing I had done in a long time. Subscribe and hear the rest of it. What I noticed first after the sentence was not Luis, it was Maria. As the clerk finished the paperwork, she stood, walked around the corner of counsel table, and handed him a folded sheet of paper with her mailing address and phone number written on it. She said, "If you're late on a payment, call me before you disappear." He said, "Yes, ma'am." That was all. It was enough. Before I stood up, I squared the file with my fingertips. I do that every day. On that afternoon, it felt different. The file had entered my courtroom as an amount. It was leaving as a set of obligations tied to an actual life. The first review was July 11th, 2025. He came back with proof of insurance, proof of driving course enrollment, and 2 money order receipts. Maria was there. When I asked whether he had paid on time, she said, "He kept every date you set." I have heard more elaborate praise in court. I do not know that I have heard better. The one date I carry most clearly, though, is June 11th, 2026. By then, the case had been closed. A note came to my clerk from the director at St. Raymond's. It said Luis was still showing up on Thursdays at 12:18 p.m. during his lunch break to help carry in meal trays because, as she wrote it, the seniors expect his face now. That was the note. Short, exact, enough. There was no appeal. I will tell you honestly what that meant to me. It meant the people who had to live with the sentence accepted it as something they could stand on. Thank you for staying with this story. It is not the kind of story people usually tell about courtrooms. Subscribe if it is the kind of story you want more of. I have more to tell. What I have come to believe is this: mercy that asks nothing is weak, and punishment that builds nothing is lazy. It would have been easier for me to read the top number in the range and call that fairness. Easier is not always cleaner. Easier is often just faster. This case gave something back to me as a person. It gave me back patience. I do not mean patience as a mood. I mean the discipline to keep looking until a lawful and human answer comes fully into view. I've seen enough bad outcomes to know a good one when it stands up quietly in front of me. If you have been where Luis was, if you made a real mistake, caused real harm, and now live with the question of whether there is still a path forward, I can tell you one thing I look for from the bench. I look for unguarded responsibility, not polished regret, not borrowed language. I look for the fact you admit, even though admitting it does not help your pride. Start there. Then match it with conduct so steady that your next facts begin to tell a different story. And if you have been where Maria was, harmed, tired, and unsure whether mercy is even something you want to be asked about, I will not tell you what to want. I can only tell you what I have witnessed. When victims choose measured mercy, the ones who seem most settled later are usually the ones who were clearest at the start about what they actually needed. Not less truth, not less accountability, just no extra ruin for the sake of display. I want to return to the image I opened with. Every Thursday at 12:18 p.m., he parked beside St. Raymond's Senior Meal Center on Potters Avenue, carried in insulated meal trays, signed the sheet, and went back to work. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you come to the comments, come the way people should come to a courtroom, ready to speak plainly, ready to listen closely, and ready to leave room for a person to be more than the worst thing on the page.